Should you talk to the police? After 28 years as both an organized crime prosecutor and criminal defense attorney, my answer is almost always the same. Exercise your right to remain silent and ask for an attorney. But here's the truth that most lawyers won't tell you about. In certain federal cases, there are limited circumstances where cooperating and just being truthful with the right protections in place can actually help you. Let me explain. In state court cases, the advice is simple. Do not talk to the police, period. There is rarely any benefit, and everything you say will be used against you. Federal cases are different. The federal system has built-in mechanisms that can provide real benefits for cooperation. Two of the most important are safety valve and cooperation under a proffer agreement. Safety valve allows a federal judge to sentence you below the mandatory minimum in drug cases if you meet certain criteria. And safety valve does not require you to inform on anyone else. You only need to provide a truthful account of your own involvement. But not everyone qualifies. There are specific disqualifiers you need to know about. First, your criminal history matters. Generally, you cannot have more than one criminal history point under the federal sentencing guidelines. Second, no violence or weapons. If you used violence, made credible threats, or possessed a firearm in connection with the offense, you're disqualified. Third, no serious injury or death. If anyone was seriously hurt or killed as a result of the offense, safety valve is off the table. Fourth, you cannot have been a leader organizer. If you supervised others or were part of a continuing criminal enterprise, you don't qualify. If you meet all these criteria and provide a truthful statement about your own conduct, a judge can sentence you below the mandatory minimum. The difference can be enormous. A 10-year mandatory minimum could become 5 years or less. A proffer agreement, sometimes called a queen for a day agreement, lets you provide information with prosecutors with certain legal protections. Your statements generally cannot be used directly against you at trial. But here's the critical part. These critical protections only work when you have an experienced federal defense counsel guiding you every step of the way. Without an attorney, without a written agreement, nothing you say is protected. Can police lie to you? Yes. They can claim they have evidence that they don't have. They can say cooperation will help when it may not. Even innocent people say things that get twisted and used against them. So what should you do? If law enforcement contacts you, remain calm. Say this: I am exercising my right to remain silent and I want to speak with an attorney. Then stop talking. If you are facing a federal investigation or federal drug charges, call my office at 214-526-1900. The decision you make right now can determine the outcome of your entire case.